Now, most welcome to Getting It Right, COVID-19 Restrictions and Human Rights, the second webinar in a series on the corona pandemic and society, organized by the School of Economics, Business and Law at Göteborgs University, to prove that intellectual life is emphatically not coming under a standstill under lockdown measures. Now, my name is Gregor Knoll. I'm a professor of international law. I have the pleasure to serve as your host and your panel chair, depending on your capacity. Now, I'm truly happy that you joined us all. We know we have a very broad audience stretching from Buenos Aires down to, I don't know, Gothenburg itself. And we are really happy to have you with us. And we are really happy that you, as we do, believe that intellectual life has to go on under lockdown and exchange has to persevere. Now, you've probably, or I'm quite sure that when you entered this space, this webinar, you've been alerted that the webinar is recorded. Let's just explain that this recording will be posted online, and it allows us to reach an even larger audience. And let me assure you that you, as part of the audience, as an attendee, you will neither be seen or heard in that recording. You can ask questions to a panelist, and that you do by using the chat function. You have a button at the lower end of the screen, which is called chat. When you open it, you can type a message to the panelists and to me as a chair. And there you can post a brief and courteous question to any of the panelists or to all of them, and it will be my pleasure as a chair to select among these questions and see to that we fit them into our temporal framework, which is 1 hour. Just to be sure, these questions can only be seen by the panelists and myself, not by the audience at large. So for attendees at large, the experience of following discussions is undisrupted by the chat function, so to say. Right, let me move on and present today's panel, which I have the privilege of having with me today. All of them are experts in international and human rights law. And let me start out with Bhupinder Chimni, who is a distinguished professor of international law at the Jindal Global Law School at the OP Jindal Global University at Sonipat in India. Joining us from Delhi, welcome, Chimni. Second, we have Bhupinder Norge, who is an associate professor at the Department of International Relations at the Central European University in Budapest and Vienna. You're joining us from Budapest, I understand, and you're most welcome, Bhupinder. Third, we have Karin Åberg, who is a doctoral candidate at the Department of Law at the School of Economics, Business and Law at Göteborgs University in Sweden. And you are joining us from Gothenburg, I take it. Welcome, Karin. Now, for you as attendees, let me just tell you that I'm going to address our panelists via the informal Scandinavian name conventions. So to me, they will be Chimni, Bhupinder, and Karin, and that is basically self-selected. So the format is very, very simple. I'll myself do a very, very brief introduction to the overall topic of restrictions, COVID restrictions and human rights law. Then I will give the floor to each of the panelists, and they're going to have it for 8 minutes in the first round and another 5 minutes in the second round. The remaining time will be devoted to your questions and a kind of an inter-panel discussion that might be engendered by them. And then I think an hour will be gone, and corona or not, it has 60 minutes, so we have to be a bit attentive of the time factor as well. Now, let me proceed to my introduction of restrictions and human rights law. Now, we can have a number of legitimate questions here, can't we? As a matter of human rights law, can a state restrict my liberty? Can a state restrict my right to assemble with other people? Can it restrict my right to be educated? And so on and so on. We can ask a lot of these questions. And also can a state declare a state of emergency and amass exceptional powers with the government in the name of fighting COVID-19? Or something which is very current in the debate right now, can a state move away from lockdown measures, although there is the looming danger of infection still of a second wave? Would not a right to health block such an early move away from lockdown measures? So these are questions that one can ask, questions to human rights law. And let me just set out a few fundamental concepts here that might help us in thinking more clearly about them. To start with, there is the term restrictions of human rights. You might think that anything that falls short of human rights is a violation of international law. That's not the case. We have some leeway for states which they can use to, well, actually impose restrictions on human rights. Take the right to assembly, the right to peaceful assembly, which I already named. It actually says in the relevant international treaty, which is called the International Covenant on Civil and Political Rights, it says in Article 21, which enshrines the right to peaceful assembly, that no restrictions may be placed on the exercise of this right, other than those imposed in conformity with the law and which are necessary in a democratic society in the interests of, and that number of interests named, amongst them, the protection of public health. So you can turn this sentence around and say, well, yes, restrictions may be placed insofar on the exercise of the right to assembly, insofar as those are imposed in conformity with the law and they're necessary in a democratic society in the interest of the protection of public health, which would encompass measures to fight COVID-19. So necessary in a democratic society seems to be a key term here. And this suggests that the means used, the restrictions in this case, they must be proportionate to the ends sought, hindering the spread of the virus in this case, and thereby the protection of public health. So it all boils down to a reasoning on proportionality. Restrictions and their lawfulness brings us at the end of the day to a consideration whether they are proportionate to achieve the end that is sought. Right, so this is the first category. There are not necessarily any temporal restrictions, any temporal limitations imposed on these restrictions. You can keep them as long as you can legitimize that they are proportionate. That's different from the state of emergency, which is an altogether different concept, which is larger in its reach than the concept of restrictions. State of emergency in conjunction with COVID-19 has been declared by a couple of states, Costa Rica, Ethiopia, Jordan, Mexico, the US, some of them. In Europe, you find that Albania, Armenia, Estonia, Latvia, Moldova, and Romania have registered declarations with the Council of Europe that they declared a state of emergency and that impacts on the human rights obligations that they have entered when signing the European Convention of Human Rights. So there are a couple of other states like Spain and Italy which have declared states of emergency under their constitutions without registering these states with the Council of Europe, which can raise issues in the long run, which we need to keep an eye on. And then we have states that have used emergency powers, as the UK, without declaring a state of emergency. So all these states which have not made use of the declaration mechanism under the European Convention must thereby have implied that the measures they're using are restrictions and in keeping with the space provided for restrictions. So that's a different regime, if you so wish, that they have used. Okay, how about the reach of restrictions and the state of emergency? Do they impact all human rights alike? No, there are some rights, and that's important to remember, that are absolute, that can't be restricted or derogated from, even in a pandemic. Examples: the right to life, the right not to be tortured, the right not to be treated inhumanely. And finally, we should all be aware that human rights also oblige states to do things in order to protect those human rights. These obligations are called positive obligations. So take the right to health, Article 12C of the International Covenant on Economic, Social, and Cultural Rights, which is the relevant treaty where you find a global right to health. It states explicitly that the control of epidemic diseases by the state is a part of everyone's right to health. So if a state abstains from taking measures to protect the right of health of persons under its jurisdiction, this might be a violation of that right. How do we know? Well, again, it is a question of proportionality. You are relating the means used to the ends sought. It may be very well the case that a state is under a human rights obligation not to end certain restrictionist measures in order to protect the right to health of the persons who are present in its jurisdiction. Whether this is the case can only be found out in the concrete case by looking at the available information and making a proportionality assessment. So I think that's that. You now know a thing or two about restrictions, derogations. You know that there are certain absolute rights which remain unaffected in their validity, and you know that there are positive obligations on the human rights law that actually bring states to uphold certain restrictions, and if you so wish, that also bring rights into collision with each other, the right to health versus the freedom to assemble, for example. Now, so much for my introductory words. I shouldn't stand in the way of my eminent panel. I would like to start with Chimni and the global situation as much as the Indian situation. So, Chimni, please, the floor is yours.
Thank you, Gregor, first for inviting me to be part of this conversation, and secondly, of course, for giving me the floor. What I propose to do in my 8 minutes is to spend 3 minutes on identifying 2 or 3 global factors that may have a bearing on the question of restrictions and its relationship with human rights, and then briefly deal with the situation in India, identifying some of the legislation, the laws that are involved in the process of prescribing a lockdown in the country. Let me first turn to some of the global factors. Now, I think one factor which has a direct bearing on the restrictions that are going to be imposed by a state, either now or later, when there is a second round of the pandemic, possible second round of the pandemic, is directly related to the state of public health care in a country. So my hypothesis here is that the condition of public health care will define the intensity and the scope of the restriction. The poorer the state of health care, the more the restrictions may have to be imposed in a country. Now, in the past few decades, with the neoliberal, global liberal economic order in place, we have seen the increasing privatization of healthcare and the lower expenses on public healthcare. Take the case of India. India spends just about less than 1.5% of its GDP on public health care. And in recent years, we have seen the increasing growth of the rapid growth of the private sector to deliver healthcare. But the private sector has been somewhat absent in its response in its response to the COVID-19 crisis in the country. So in a sense, the point I want to make is that the global order is complicit in some way and has a bearing with the kind of restrictions that are being imposed in individual states. The second thing is that how the global community, international community will address the issue of affordable access to vaccines when these are discovered, along with other drugs and equipment that is required, will again have a bearing on restrictions. While the UN General Assembly has called for cooperation and solidarity, I've also heard talk about the role of intellectual property rights in terms of the pricing of the future vaccine. This again has implications for the restrictions, and it's very important that either free or affordable access is given to developing nations, as the resolution of the General Assembly is called for. The third thing I wanted to mention, global factor, is that I don't know about the numbers. You mentioned a few countries, but there are figures ranging from 70 to 80 countries which have some form or another of emergency. I saw this on the Center for Civil and Political Rights, which collects these figures. And therefore, this is a matter of concern because we know that if governments see other governments undertaking such actions, that is going to again have a bearing on the legitimacy of the restrictions, if not the legality of the restrictions. And the fourth question I wanted to simply flag was that while the International Human Rights Covenant clearly cover the ground, my sense is that many of these covenants, even the principal ones, did not have a pandemic of this scale or order in mind. And so there may be some ambiguities and gaps which may require to be addressed in the future on the lines of, for example, the 1998 UN guidelines on internally displaced persons. It was recognized that those rights were available in the covenants, but they needed to be distilled and separately presented. So these are some of the factors which are going to come into play, both in assessing the legality and the legitimacy of the restrictions, as well as ensuring that in future, these restrictions, in the absence of the necessary medical infrastructure, do not become, are not increasingly employed. Now, turning to India, the first thing I probably need to mention is the sequence of events. On 24th of March, from 25th to 14th April was the first country-level lockdown for a period of 12 days, for 21 days. Subsequently, from 15th April to 3rd May, there was another period of 14 days of lockdown. And now there is a lockdown from 4th May to the 17th May, but with the easing of restrictions. The whole country has been divided into different color, red, orange, and green. And the restrictions vary from district to district, depending on the state of the virus in those districts. Now, so far as the legal basis of the action of the state is concerned, in terms of ordering the lockdown and other actions, to the best of my knowledge, there's no formal emergency which has been declared. In fact, the Indian Constitution does not envisage such a public health emergency. So the entire lockdown has been ordered under what is called the Disaster Management Act of 2005. And the Disaster Management Act, Section 72, gives overriding powers to the federal government to order this lockdown. The second law which has been used is the Epidemic Diseases Act of 1897, Section 2 and 2A of which gives powers to both the state governments and central governments. It's the state governments in the Union that have invoked the Epidemic Diseases Act of 1897 to undertake a number of measures and impose a number of restrictions. Finally, there have been provisions of the Criminal Procedure Code which have been used at the local level by the district magistrates or commissioners of police to order to stop movement of persons. Now, turning to the specific rights which have been, which are involved. First, of course, I need to mention that only 4 hours notice was given for a nation-level lockdown of 1.3 billion people. And this actually meant that there was complete uncertainty among people, especially among migrant workers. An estimate of these migrant workers vary, but let's talk about a range of about 40 million migrant workers. And they began to, because of the 3 weeks lockdown, attempt to go home. But there were no real measures in place to ensure that transport back home. So thousands of them started walking home. Now the hardship and misery this involved cannot be described. They cannot be really captured in words. And many of them could not reach their hometown because there were borders at different states were closed, and so they were often caught in no man's land. There were no serious relief measures, although under the Disaster Management Act, Section 12 offers guidelines for minimum standards of relief with regard to shelter, water, sanitation, health measures, But since there was no national plan in place, which is mandated by the Disaster Management Act, this really could not help. In the first week of April, there was a public interest litigation filed in the Honorable Supreme Court of India with regard to provision of minimum wages for these migrant workers. However, the court did not, was differential towards the executive and did not order immediate measures. Now, the second right that I wish to talk about is freedom of the press. Now, this issue, the issue which went before the Honorable Supreme Court of India was with regard to, if I recall correctly, fake news. The Supreme Court said that they were not willing to intervene in any way to stop the freedom of the press. But what they did say, that they directed the media to publish the official version about the development as well, so that the press and this was not very welcome by a section of the press, because this seemed like telling the press how to do its job. A third question which arose was the right to privacy. This was with regard to the directive of the government for the mandatory use of this contact tracing app called Arogya Setu for employees in the government, and now also for employees in the private sector. And there's been, this matter is before the court, but the view is that there is some skepticism about the authority for this measure because there is no law which authorizes the involuntary use of such an app, that you can't compel people to download this app, nor is there any legislative guidance for the application's purpose functioning.
Okay, Chimni, I'm sorry I have to break in here, but you named 3 rights. I'm sure there are more. There's a second round. I hope we can get back to others. I think that's a very helpful map that you put out for us now.
Apologies, but
not at all. Not at all.
I just wanted to say the sentences that I read out were was from an op-ed in the most respected India national daily called The Hindu. So I wanted that to be on the record.
Right. Thank you very much. Great. Okay. Now we have a global view and we have an Indian view in your bifurcated presentation, which is great. And I think we should move to Europe now. Baldajar, Hungary. How about the situation in Hungary?
Thank you, Gregor. I hope you see my slide.
Yes, we do.
And I will talk no more than 8 minutes either. First, starting with an overall frame in Hungary, explaining that the situation under the COVID cannot be understood without the larger frame. Then we will look into a few rights, and then I will conclude. This is a large table. Of course, we can't go through that, but it will be available on my website. It tells that the decay of democracy has been a long process. It affected institutional and personal elements as well as social and reflected in the narrative or the discourse, in the public discourse. So the claim here is that the democratic decay went on at least since 2010 or maybe 2012, including, for example, as you can see in the upper left corner, the limitation on the Constitutional Court's powers, filling it up with loyal judges who are sharing the views of the government, curtailing the powers of the court system and forcing elderly judges to retire, and so on and so forth. Whereas in the social field, a constant disregard of the poor and the deprived is characterizing the measures taken, including the measures taken during the pandemic, helping those who are running businesses, but not those who are employed by those businesses. And all that is surrounded by a narrative which is promoting illiberal or Christian democracy, which is essentially an ethno-nationalist, communitarian ideology, constantly attacking liberal ideas, which is not heralding much good news for human rights. Islamophobia and xenophobia are spreading, and it's an essentially sovereigntist discourse, frequently designating Brussels and the EU as a quasi-colonial power. That led to the World Justice Project to note that the Hungarian rule of law is in the 60th position globally. Now, having that discussed, let's now turn to the actual legal situation ensuing the appearance of the pandemic in Hungary. On the 11th of March, the government declared a state of danger, which it could have done, but it is not based on the constitution. Because the constitution, as you can see in the notes pages part of my slides, which you can have access to once you download them, envisages only that in case of an industrial accident or a natural disaster, can that state of danger be declared. Now, a pandemic, a health pandemic, is neither of them. Nevertheless, the court declared the state of danger, and then the parliament on the 1st of April extended that situation without deadline, which is subject to a lot of discussion and criticism. What happened under these rules? Under these rules, military oversight was established in more than 150 Hungarian companies. The military went there. military is controlling hospitals. So military personnel was sent to hospitals to control the use of the tools applied in the epidemic, so masks and all that, machinery. Sick persons in the hospitals were sent home in order to free beds, an enormously large number, 36,000, which is still questioned in the press. Why would we need so many if at the moment we have less than 2,000 persons actually being taken care of? And to characterize the situation, think of the measure of the government taking away all the locally paid business taxes, just depriving municipalities of their own resources to respond to the epidemics. And also the travel of health professionals was banned. Now, what came up very frequent in the international discourse is the new rule in the penal code, as you can see here. That's the second paragraph. The first one was there before, about fear-mongering. And this second paragraph essentially says that anyone who is disseminating untrue facts or misrepresents true facts, which is capable of hindering or preventing the efficiency of protection, can be jailed for 1 to 5 years of imprisonment. Now, that is obviously subject to a lot of interpretation. When is it capable of hindering defense against the virus? In terms of liberty, the human right of liberty, there was a lockdown, which is fine, introduced on the 28th of March. But that lockdown was then eased on the 5th of May, limiting it to Budapest and pest country. The rules of the lockdown, first nationwide now in Budapest and the surrounding country, are not that severe, and so they are relatively liberal and humane, established a humane regime. You can see that there are 21 reasons for which one can leave his or her home or residence or any apartment in which the person lives. But from the 5th of May, and that is, echoes somewhat what Chimni said, the country is divided into these two parts. And in most of the country, people are essentially free to move. They can go into cafes on the terraces, and universities can reopen. Whereas in Budapest and in pest country, that can't happen. So the question is this discrimination? Is it justified? Is it proportionate? The numbers are different, but not so seriously, one can argue. Taking the next element of liberty, including the right to leave any country, including his own, and to return to the country, rules were changed overnight, and I had serious concerns with that, because these rules introduced were inhuman and discriminatory, and they also contradicted to the EU policy. Why? Because the government basically said no access to the Hungarian territory for anyone except for the Hungarian nationals who have to go to the quarantine once they return. But it excluded all third country nationals without exception, and it excluded even the European Economic Area nationals unless they had a European residence card, which assumes more than 5 years continuous residence in Hungary. So those EU citizens who have lived here for 2, 3, 5 years, but have not acquired that residence card, they were also banned from returning, provided on the 16th of March they were abroad, even in the neighboring countries. And then later on, an exemption procedure was introduced, but it assumes that you have to apply for the deputy of the National Chief Police, and you have to show that you are not sick, etc. So this raises questions in the context of family unity, property rights, acquired rights, EU mobility rights, and non-refoulement as well, because essentially everybody is excluded, except for the long-term EU citizens, long-term resident EU citizens. That system underwent 5 changes, so predictability as an important measure of the rule of law was not there either. And in a most interesting way, an amendment was introduced in effect since 1st of May, which says that if you come from Austria, the Czech Republic, Germany, Poland, the Republic of Korea, and Slovakia, then you are exempt from these restrictions, which is really, really strange. And at the same time, the Injunction against the removal, that is halting the removal once it is ordered in an expulsion measure, is no longer suspending the removal, which raises the question of an effective remedy. Coming to the last right to be discussed before I finish, the right to asylum was gradually destroyed since 2015. Here you see the list of those steps. I will only highlight two of them. One, that a crisis situation caused by mass immigration, as it is called, was introduced in 2015 and has been maintained since, without the conditions as laid down by the law ever being met. So we have a practice in special legal orders being maintained without any foundation. And that crisis situation is used as a pretext to apply that very specific asylum procedure which is applied, which led to only one person per day being admitted to the transit zone and every asylum seeker being pushed across the fence with Serbia. That is removed without any formal procedure. The second element I want to raise is that in 2020, March, I think the 1st of March, you can see that in the notes pages part, it was announced that Hungary will no longer receive any asylum application. Total ban on asylum. That's my last slide, the conclusion. So what can we conclude? First, let me stress that I do agree with the rights limiting measures. I think they were justified and necessary, the lockdown, the quarantine, the social distancing and all that. But in agreement with Chimni, we have to look at that in a broader frame. In our case, in the broader frame of the democratic decay and the destruction of the asylum system. What we witness is that the secularizing discourse and the involvement of the military reinforces this perception within the society of friends and foes. And therefore, if someone comes forward and raises Gregor's idea about questioning the necessity and or the proportionality of these restrictive measures, that person qualifies as a foe simply by raising that the measures may not meet the requirements of the, let's say, the European Convention on Human Rights. And Hungary has not submitted a derogation notice under Article 15. So the migration-related measures reinforce the ethno-nationalist discourse, and they were an ethno-nationalist closure, excluding everyone who came from a third country and not 5 years long resident EU citizens or European Economic Area citizens as well. So my last sentence is that the government used COVID-19 to further disqualify human rights and their defenders. So that I see that as a step towards making the Sikh democracy terminally ill. Thank you. That was my contribution. At the bottom, you see the website where I will upload these slides right after this webinar.
Thank you so much, Baldijar. That was very helpful. It also gave us an idea that already with Chimni, with your presentation, the question of migrant workers was a large issue. Now we see that the theme of migration continues to seize us, even in the Hungarian case. So we're eager now to learn what is happening at the borders of the European Union. Hungary might arguably be a very particular case and need a kind of a particular form of attention. But we should look to the margins of the political community in whose name we are looking doubtfully at the measures, certain of the measures that you named, Baldijar. That brings us to Karen's presentation and to the Greek islands. Karen, please.
Thank you, Aaron. Thank you for inviting me to this panel. So, like you said, my talk today will focus on the Greek asylum hotspots and on three core issues that they face. So, as a background for those of you who don't have this as your main interest, the hotspots are legally a type of administrative site that were established in 2015 in order to manage high influx of refugees. Today, their primary aim is to implement the EU-Turkey deal. So for the asylum seekers who enter the islands, this means that they are prohibited from leaving the islands for the mainland before it has been determined whether they should be returned to Turkey or not. It's a type of de facto detention covering the whole island. And these islands, this hotspot system is in place on Lesbos and Chios, Samos, Theros, and Kos. And together, these islands host about 35,000 people, which is more than 5 times their capacity.
Karen, I'm sorry to interrupt. I get indications from attendees that the sound is slightly problematic. Could you either use a headset or, well, I don't know, try to do something about the sound?
Yeah, strange. I haven't heard it before, but can you hear me better now?
Oh, it seems to be a difference. Yes, I see nodding. Great, thank you very much.
Perfect.
Sorry for the interruption.
No worries. So the first issue of the Greek islands, which is really the big worry, is the reception conditions in the camp. The Greek asylum system has improved a lot compared to 2011 and the MSS case, but the reception conditions still remain the weak spot. And a very critical issue is, of course, the access to healthcare, which is underfunded and understaffed. In the beginning of the hotspot system, this was outsourced to different humanitarian NGOs and French doctors' organizations. But currently it's being run by a governmental institution called the CALPNO. And they struggle a lot on finding doctors and nurses who are willing to work in this environment, which is so chaotic, and they are offered very, very little support. In case of absolute emergencies, for example, if an asylum seeker would have a heart attack or a stroke, it's possible to access the regular hospital. But here it's also important to keep in mind that this is on the Greek rural countryside. It's far away from Athens. Greece suffered very severe cuts in their welfare services following the 2008 economic crisis and the conflicts with the EU after that. So in short, there are no actual healthcare facilities on the islands that are suited to manage a major outbreak of COVID-19. And these reception conditions have been criticized for quite long, but when COVID-19 arrived to Europe, a lot of voices were raised by health organizations and NGOs to close down the camp and evacuate all the residents. As we pointed out before, it would be very difficult to control this outbreak. Hygiene and sanitary conditions are some of the worst problems, and people are living very, very close to each other and usually standing in line for several hours per day in order to access information, to access food or water. There are about 500 people per shower and 160 people sharing one toilet. So while the Greek authorities have provided a lot of information to the camp, like in the rest of the Greek society, about how to protect oneself from the virus, much of the advice that is given, such as social distancing and washing one's hands regularly, is simply not possible for camp residents to follow. So the Greek government acted quite swiftly concerning its own citizens, but they have argued that an evacuation was not necessary since there were no cases yet of COVID-19 in the camp. Since then, some relocations have taken place to the Greek mainland of vulnerable groups and people with medical history, and also of unaccompanied minors being sent to other member states and cities in those states. But this is still just a very small percentage of all the residents in the camps. But there has also not yet been any large catastrophes of people falling ill in the camps, though there has been certain corona cases. However, on the mainland, there has been larger outbreaks where the entire camp has been placed in quarantine. So most attention have been given to the issue of health conditions. But the second issue I want to talk about that seems to be gaining ground is the fact that COVID-19 has fueled a lot of nationalism and fear and hate directed towards non-Europeans and people on the move. So recent weeks, there has been at least 10 cases of asylum seekers arriving to the Greek mainland and then being taken by police authorities, placed on life rafts, and pushed out in the sea in the direction of Turkey. There are also reports of newly arrived migrants being removed in vans by police officers, and when the police officer inquired about where they went, the authorities deny that they were ever there. So people seem to be rearranged, but it's difficult to know yet whether they are being placed in quarantine, whether they are taken to new camps on the mainland, or whether they are being pushed back to Turkey. And apart from the authorities, violence has also increased due to fear and conflict within the camp in this new situation, due to the local population being tired of having their towns transformed into an EU buffer zone or transit zone, and also due to right-wing extremists who travel to the islands to start fights. So there has been a lot of fires in the camps lately, as well as examples of asylum seekers being shot at. But I should also mention that this increasing violence against migrants began already before COVID-19 reached Europe, due to the situation earlier this spring when Turkey withdrew their coast guards and allowed refugees to travel to Greece, with the result of Greece temporarily exempting the right to seek asylum. So it's difficult to say what in this situation that is caused by COVID-19 and what is caused by the tension between EU and Turkey. But it appears like the violence keeps increasing despite the situation between Turkey and the EU being at large back to how it was before. So the third issue I'd like to bring up is equally important, the problem with issues of the EU migration policy that has existed for long, that becomes aggravated and highlighted in times such as these and contribute to this chaotic situation, mainly speaking about lack of solidarity, which contributes to the two issues I've mentioned before, but also the lack of legal pathways. Earlier this spring, the European Commission banned all non-essential travel to Europe, and then also made an exception for people who come to Europe to seek asylum, which is greatly ironic, I think, since, as we know, it's practically impossible to travel to the EU to seek asylum through regular means. And the effect of this is also that it's not possible to temporarily pause the admittance of asylum seekers to Europe due to COVID-19, since it is already permanently banned, but takes place anyway through the means of smugglers, thereby moving the control of the movement to the smugglers away from state authorities. So in a similar sense of what Baldassar was speaking to, it's also a situation where issues that have been around for long becomes greater and becomes aggravated in this new context. So to say something a bit conclusive before I stop speaking, human rights issues that are raised in the context of the Greek hotspot and COVID-19 are quite similar to the ones that have been brought up before, concern social rights, access to health and access to water, but also the prohibition of discrimination and the prohibition of non-refoulement. And similar to other countries, the virus affects all people, but disproportionately affects people who are poor and vulnerable, including ethnic minorities and migrants, because these groups seem to be met with more repressive population control and offered less resources and support than the majority population. Thank you.
Thank you, Karen. That was a great overview. Thanks so much. Now it seems, or to conclude on the three presentations here, that COVID is a problem booster. We had a number of examples of pre-existing human rights issues that really went large, went from, known to larger ones with the crisis. So that's perhaps something we would like to keep an eye on. I've been a very lenient chair. In these times of lockdowns and restrictions, I didn't feel to be a kind of a strict temporal enforcer of the order, which deprives us from a second round, but not from the questions by the audience. A very simple question, which nevertheless is important. ask to you, Chimni, which is the name of the app, of the contact tracing app that is mandatory to use for Indian, I think, civil servants. Could you just repeat that so that enables further research?
It's called Arogya Setu. Let me spell it out. A double A.
You can write it into the questions and answers. You can write it into the questions and answers, and then we will see it.
I can write it for you, actually. Ah, no.
Double A R-O-G-Y-A Setu, S-E-T-U.
Sorry, R-A?
R-O.
Double A R-O-G-Y-A and then Setu, S-E-T-U.
Yes. Oh, I'm losing you. Can you see that? A-R-O-G-W-A-S, and then?
No, it's double A R-O-G-Y-A and then Setu, S-E-T-U. So how do I write it down?
Can you open the question and answer thing?
I tried to answer that.
Okay, you did actually, right.
Is that correct?
Yeah.
Can you see that if you go to question and answers and look at
Arogya Setu?
Yeah.
Yeah, great,
Okay,
wonderful.
good.
Okay, I think that's already dealt with. That's dealt with too. We have another question here, which I would like to float first. That's to what extent the speakers think that the pandemic will introduce new human rights norms. Chimni, you made mention of the necessity or the probability of a soft law instrument emerging here. Is there any response you would have to the question of whether there might be a new human rights norm emerging from that? It could go either way.
Yeah, I think what I was underlining was the need for such an instrument, because as Baldiza mentioned, the range of human rights that are an issue, even listing them would take 8 minutes. And to be discussing them and the validity, legality, legitimacy of these measures in individual states would require, you know, a considerable amount of thought and research. But all I can suggest, all I do feel is that we do need a separate instrument to deal with the pandemic of this order and the soft law. And the second thing is that integral to that would be a norm which requires the sharing of the vaccines, the protective equipment, and other drugs available to deal with this, to deal with COVID-19 or any other pandemic. There should be an obligation on states to cooperate on that front. That should be part of this human rights instrument, because I think one of the problems that we are going to confront is that as deglobalization takes place and each nation state to itself, while the right noise is being made, the 8 billion funds, euro, which has been collected in order to assist research, we do not know whether at the end of the day that would be shared with poor nations, and within poor nations, whether those would be made accessible to the poor in the poor nations. So one of the things I wanted to, there were two things I wanted to mention. One, of course, I think at a theoretical level, we also need to think about this whole COVID-19 in class terms, if I may say so. Because what is revealed by the Indian state in response to the migrant workers was a certain class blindness. Is it as if it were that, you know, the suffering of this section of the people was not visible at all, had not been taken into account, and that response was post facto. And I think this cuts across nations, this cuts across groups. If you look at the United States, there is a disproportionate number of African American people who have succumbed to COVID-19. That could be because of a range of factors, but one is also access to public health care. The other is the inability to practice social distancing in the within the places that they are in the places that they are living in.
Right. I see this corresponds actually to the situation you're describing.
So what I'm suggesting that it's the poor across the global south, across the global north who are suffering. The other, that in every country, the minorities are facing a very difficult situation. Whether it be ethnic minority, linguistic minority, or maybe you know, migrants and refugees, and it is no different in India. There, the minority Muslim community has faced a degree of harassment and from private citizens and groups. In fact, I wanted to draw your attention to a letter that 101, and this is a matter of very heated debate in this country. So I just wanted to cite one sentence from a letter that has been written last week by 101 former distinguished civil servants who are apolitical. And that's why I wanted to cite the letter that they have written to the chief ministers of different states of the union. And they say that the fear and insecurity generated by the pandemic is sought to be channeled into the othering of the Muslim community in different places to keep them out of public spaces, purportedly to protect the rest of the population. And therefore, the letter calls upon states to ensure that all entitlements, including medical and hospital care, rations and financial assistance, are available equally to all those in need. So apart from class, it's the minorities who are suffering.
That's very clear. Yeah.
I think we haven't talked about the gender dimension.
But Chimni, the problem is that
violence.
Sorry, I have really to break you off because we have 3 minutes remaining. I'm sorry, but you were very clear on the problem of class and of minorities. So this
gender, really, I just wanted to flag it.
Right, gender is flagged. We can't do justice to it now, but it remains an important issue. I would like to try to get a few more questions tabled in the 2 minutes that we have. Let's at least make an attempt. There's one to you, Baldajar, and it reads, allegedly, a recent government decree in Hungary, I understand, allows the police to access personal data of any citizen. Is that true? And what are the possible consequences?
Well, I think the person raising the question might refer to I don't know whether it's a decree or an instruction of the minister responsible for health, which enables exchange of data related to the health situation of persons between different institutions which might rely on that. So it's the pandemic-related exchange of information, not the overall exchange of information on the persons. Now, it won't fit into the 2 minutes, so now 1 minute left to discuss to what extent we are willing to give up our privacy in order to avoid certain social dangers. That would require another webinar to discuss to what extent that trade-off can work. But indeed, there is a rule which enables police to get access to more information than before.
Good, thank you very much. Now, there's one more question which I would just like to flag. There are a couple of very good questions, thanks to all of you who've been writing in the in the chat field here. There's one which I would just like to flag in order to get it out into the open, and it connects to some of the issues of free speech that have been raised by Chimni and by Bhupinder. Let me just see whether I can find it again. Yeah, here it is. It is actually about the intermediaries we have in today's information flows, the media, which includes Facebook and YouTube. And the question is about there being videos deleted, news and posts are deleted that are not aligned to the official message that the states want to send out. I think, Chimni, you made mention of an Indian example that falls into line. Now here we have private actors that are rather vital to the information flows that we have, that are not subject to human rights norms in the same way as states are. Whatever states do or do not do can immediately be assessed as to its lawfulness under human rights norms. The problem we have with private actors is that we need a state to go after them to protect human rights that might be infringed by whatever these actors are doing. So let me just flag for the importance and the complexity of that issue. And it could very well in its own right be a subject of a webinar of its own. I think we've coming to a close now. I would like to do two things here. I would like to thank our three panelists from all my heart for being with us today and sharing their knowledge with us. I would like to thank you out there who are attendees, more than 100 still at this point at the end of the seminar, and we're beyond its official end temporarily. That's absolutely great to have had you with us in this learning experience. And I would like to invite you all to join on our next webinar in the series, which will deal with the question of what is the optimum level of measures to prevent the spread of diseases. Again, answers are given within 1 hour. It'll take place on 13th of May at 12:30 CET. So 13th of May, 12:30 CET, what is the optimum level of measures to prevent the spread of disease? And more information at handels.gu.se, that is handels.gu.se. And at the same site, you are all courteously invited to fill out a poll on today's event to help us improve on these webinars. You just have to click on today's event. So thanks very much. Hope to see you somewhere again. And finally, take care of yourself and keep the flow of thoughts alive.
Thanks.
Thank you.